So it's my pleasure to introduce my friend and colleague, Sandy Kovacs. Sandy is a leading personal injury lawyer in Vancouver. Prior to working in this area, Sandy practiced as defense counsel in aviation, in medical malpractice, in personal injury claims, and historical sexual abuse claims. Sandy's current practice includes litigating complex claims arising from motor vehicle accidents, medical malpractice, and historical sexual assaults. She is also an adjunct professor at UBC Allard School of Law, teaching Law 435C, personal injury law. And Sandy also practices in the Yukon and is a member of our bar. Sandy has had some incredible trial and negotiated settlement results in her career. Most recently, her results include Anderson and Molon, which was a historical sexual abuse claim and direct negligence against the Roman Catholic Church, in which record punitive damages were awarded. There's also, I may butcher this name, but Yui versus Dhillon, where she achieved a record damages award for a severely brain injured plaintiff in the excess of $9 million. Throughout her career, Sandy has been a mentor to several lawyers, including myself. I have certainly grown as a lawyer with the help of Sandy, and she continues to mentor me and take my calls regularly. Sandy is an incredible mentor, teacher, and I am thrilled that she has agreed to take us through the life cycle of a file.
Thanks, Megan. Thank you to you and to the Law Society of Yukon for having me today. And thank you for that introduction. I appreciate being your mentor, although that makes me sound a lot older, which is troubling to me. But in any event, I'm going to try, this is going to be really an overview because, we teach the personal injury course at UBC, and each of my slides really could be a 90-minute session itself. So it's going to be tough for me to sort of stick within my time limits, which is standard for me when I'm in trial as well. I'm terrible at underestimating my time, but I'm also going to do my best to keep you folks entertained for the next 90 minutes if I can. When are we supposed to end this? I don't know if I actually asked that question before, so I know when my time limit is up. Like 1:15-ish or 1? Or
I think 1:30.
1:30, okay. We'll keep going to 1:30. All right, so my associate, who is far more technologically capable than I am, has actually created a PowerPoint for me. So I'm going to share that so that you have something to look at besides my face for the next 90 minutes. Lots of fun memes in there too, so we'll stay entertained that way. Okay, so let's see. Does everybody have that share screen? We're good? Megan, you can see it? Perfect. All right, so I've been asked to just talk about, the life cycle of a litigated file from beginning to end. And what I hope to do with walking you through this is sort of share my approach to claims and sort of what I think about and what I say and what I do sort of moving from step to step in the litigation. And I do feel that litigation is much more of an art than a science, and you have to do what you feel is best in your skin. I can't be the same lawyer that my colleague Mark Kazmierski is. I'm not the same person. I have a different personality. And so, that's my advice to you as well with each of these steps. These are meant to be just sort of tidbits. Hopefully, you can take what you like, leave the rest. But, hopefully there's something there that may be helpful to you in your practice. All right, so now I have to figure out how to, oh, there we go. Brace yourself for a riveting presentation. This, of course, is my associate's meme here. So litigation is coming. It's meant to be exciting. I am proud to be a litigator. I don't think I enjoy very much or enjoy being a solicitor very much. I tried a little bit of it when I was articling. I found it boring and confusing. So litigation is my thing. I find it exciting and a bit thrilling, which hopefully some of you do as well. I thought I'd just start by saying, what is it about litigation? That's great. What are the pros and cons of it? And of course, I've got an overview as well. I'm going to hit all these topics, hopefully in the 90 minutes we have today. But I'm going to start with, is being a litigator worth it? And I don't think we're born litigators. I think we're born with some skill sets that allow us to have a platform to learn more, to become a better litigator. But, generally speaking, I think the secret ingredient is that you care. And that you care about your clients and you care about doing a good job and that you have a bit of a type A personality in you. But it's a tough job. It's not an easy one. There are probably easier ways to earn a living. The risks are usually high in litigation, especially if you're acting on the plaintiff side. I feel a lot more risk for my clients now than I did working on the defense side when I worked for sophisticated insurance companies. Your desk is never clear. You take your work home with you. It affects you day and night, keeps me up at night. I'm sure it keeps many of you up at night as well. And so there's a great personal cost, I think, to being a litigator. But I think equally there's a great reward too. And I have really experienced that reward time and time again in my career. I worked on the defense side for more than a decade, and I loved it. I got to travel. I worked for insurance clients as far away as London. I got to come to Whitehorse, which is how I got my ticket up there. And I really am friends with some of those former clients to this day. And for the last 5 years, I've been doing exclusively plaintiff's work. It was a lot of fun to switch sides to get a different perspective. And quite frankly, I haven't looked back. I enjoyed the defense work, but I really enjoy being an advocate for, more vulnerable plaintiffs and for the underdog. And what I think has really changed for me is feeling like I can make a difference in someone's life. And that to me is worth the cost. And so that experience has really been quite exceptional. Let's start with, first of all, I've got the pros and cons here, which aren't very different. So you're always learning something new, which is challenging sometimes. But of course, it's never boring, but we're never having a rest either. So getting retained. So, obviously very different on the defense versus the plaintiff side. I'll talk a little bit about what it's like to get retained by a plaintiff and sort of what that conversation is like and what kind of questions need to ask and what kind of answers and information I give to prospective clients when I'm meeting them for the first time. And I can tell you in personal injury work, especially with the motor vehicle work, which I do a fair amount of now, the question I always get is, well, what's my claim worth? What are we aiming for? And I always say it's not my job to tell you. Really, it gives me an opening to explain what my job is. And really, I say to them, look, my job is threefold. My first job is to build the evidence to support a meritorious claim, to gather together the medical evidence, to sort out what your losses are, and to build the biggest possible claim so that I can present as much risk to the other side as possible. And then my second job is to give advice on risk, and that comes later. So when the defendant or defendants put an offer on the table, it's my job to tell you if that is something I can beat at trial, or if you want to take the risk of going to trial, or if you want to settle. I hopefully can guide you at that point in time. And then my third job is if it's not enough money, if there isn't a settlement offer on the table that's fair, my third job is to take it to trial and be your advocate through trial. And so that really is an opportunity for me to explain, to manage expectations for the client and to explain my role. And often when people say, what is my claim worth? I also tell them it's too early to tell you that. Sometimes injuries haven't crystallized yet. If it's still early after the accident, we want to wait and see how things unfold. Are they going to be able to go back to work? If so, in what capacity? And so, it also allows me to explain timing and, give them expectations in terms of when a claim is going to get resolved. Obviously, really important to explain your fee. On the plaintiff side, we obviously work on contingency fees, and I explain how that works and ensure that they understand it. And I've included a bullet here about trauma-informed approach. The area that is really growing in my practice is the historical sexual assault work. And many of these people that come to me, it's the first time that they're disclosing what's happened to anyone, or maybe the fourth or fifth person they've ever told. They've been holding this in for years, and it's an incredibly difficult call to make, to actually say, look, what can I do about this? And most of those people that come to me have very low self-esteem, have a very difficult time articulating themselves, are unsure about what they want to do, and frankly are terrified about moving forward. So I never have just one meeting for an intake on a sexual assault client. Usually it's at least 2, if not 5. And in a couple of my cases, I have literally talked to people for 3 years before they decide to sign. And I don't pressure those clients to move forward, and there's no limitation period, thankfully, for sexual assault, at least not in British Columbia. And so they have all the time in the world, and it doesn't do me any good to push someone forward unless they're ready to do it. Because I also tell people that litigation is not sunshine and rainbows. It can be really difficult. especially for someone who is suffering from trauma, because they're going to be triggered frequently throughout the process. And hopefully at some point we'll get to a point where we can reduce those triggers, but we're not there yet. The theory of the case. So really important when you take on a claim or when you pick up a new file, whether you're on the plaintiff or defense side, figure out what your theory of the case is. And it doesn't have to be static. It can change over time, but what are the facts? What's the law? How does this all fit together? What's your analysis? What are you going to argue at the end of the day? And if it's from the defense perspective, you obviously want to have a theory that reduces your client's exposure. From the plaintiff's perspective, you want to have a theory that maximizes the recovery. And so, when it's someone who is young, you want to look at the different employment opportunities that they could have achieved, but for their injuries. When it's someone who's older, you want to figure out various ways to maximize their claim, even if they're retired. You can look at housekeeping capacity, et cetera. But have your theory of the case at least written down and formulated in your head, at least, as you're moving forward, because it informs all the questions that you ask. It informs the document discovery that you engage in. And so identifying your theory of the case early on is quite important. Having said that, it can change. I've changed my theory of the case frequently, sometimes when you're in trial based on how the evidence comes out, but that's not a fun place to be. So ideally you want to have your ducks in a row before then. Pleadings, foundation of the lawsuit, critical. You want to be concise. You want to obviously make sure you have adequate particulars. But my lesson here is it's practice, not perfection. I'm not going to tell you that I'm perfect with my pleadings, because I'm not. I got a demand for particulars just last month on a file. I especially get them on sexual assault files because it's very difficult to plead date, time, location, and you get those demands, and I'm thinking these poor people can't sort that out often. They can't figure out sequencing of what happened when either. But really, you have to be able to give enough notice to the defendant that they can properly defend the claim. But if you get a demand for particulars or an application to strike, I haven't faced an application to strike, but it's not a mark of failure on your part or incompetence. Just fix the problem. You can amend. In Anderson and Molon, which is the Catholic Church case I amended the pleadings at the close of the trial. It's actually fairly simple to amend if there's no prejudice to the other side. So if you're not alleging a new cause of action, you're just trying to have the facts pled fit the causes of action and the claims. You can do that. And the reason I amended in that case is because I wanted to ensure that I was going to get a significant punitive damages award. And I did. I actually got $400,000 in total at the end of that judgment. $150 against the church and $250 against the perpetrator, who was unfortunately incompetent. But in any event, revisit, amend, but just make sure you look at that every now and again. It is important to ensure that your pleadings are accurate. Document disclosure, critical step, obviously. I concede that in my practice, especially the motor vehicle stuff, my staff does a lot of the document production for me. But having said that, they're also well trained to recognize when they need to come to me about an issue. Should I make this redaction? Is this privileged? Should I produce this, et cetera, et cetera. And so the lawyer has a responsibility to ensure that we're meeting the rules of court, that the documents are properly being produced, that are relevant, and that we're not missing documents that we should be able to produce. And the other thing is to recognize when the other party sends over their list of documents, what is missing from it. And making your demand for further and better documents, or whether it's, if they've claimed privilege over something, you can ask for a further and better description of what the nature of the document is and the privilege claimed, because you may want to challenge that. It might be something that may really help you prove your case. So, pay attention to what they're doing. One of the things I did in the Anderson and Molon trial, maybe it's my personality, but I like poking the bear to some degree. And that trial went on in 3 stages. And so in one of the breaks, it came up in my cross-examination of the former Archbishop that there were a number of documents that were missing, certain committee documents that clearly had agendas and minutes that were never produced to me. And the curious thing in that case as well is that the perpetrator's personnel file was missing the critical year before the incident with my client, and he was a known, in the Archbishop's words, playboy. I use the word predator. But in any event, I knew that there were documents missing, and they must have been created at some point. And I knew it wasn't going to get a result, but I did it largely to prove a point. But I actually served a document application on the Vatican's embassy in Ottawa, which is called the Papal Nuncio. And I did that because my opposing counsel was suggesting that he was just acting for the little old Bishop of Kamloops, and this wasn't about the larger Catholic Church. And all of a sudden, lo and behold, he gets retained on behalf of the Papal Nuncio. So I get to say in court, well, my friend's now retained by the Pope. But in any event, he was thereafter no longer on the record, and they claimed diplomatic immunity. But fun, fun to launch those applications and try to see what you can get, and try to use the rules as your toolbox to access whatever documents you think you need to prove your claim or to prove a point. Sometimes it's the optics of the application that are helpful. Oh, there's a picture of the Apostolic Nunciature in Ottawa. My guy that actually served the document application said it was a surreal experience because they weren't sure they were going to let him pass the front gate when he went to serve it. All right, and forgive me, I'm just going to stop here and pause to note that, if somebody has a question, it's hard for me to see who's there. I'm sort of staring into a screen here, and if somebody has a question, I'm happy to have you jump in, unmute yourself, say something. I'll try to find you in the screen. It's a bit awkward this way to do presentations rather than in person, but I would really enjoy not just talking at everyone for 90 minutes, and hopefully if someone has something to say, use the chat button or whatever you want to do to try and say it. So hopefully we can do that. Examinations for discovery, that's what we call them here in BC. And I will say as well, forgive me, because it's actually been about 5 years since I've practiced in the Yukon. So when I switched sides, I actually went sort of non-practicing for a while because I had my baby and I wasn't taking files up there. And I recently took on a file up there. So I've now reactivated my membership in the Yukon. So forgive me, I'm a little rusty on some of the Yukon lingo and rules. So I'm really writing this from the perspective of BC rules, but hopefully the principles resonate and you can borrow from it as much as you wish. When I'm preparing my client for discovery, I do not over prepare them. I know that there are some counsel who literally create chronologies that they have to study before they go into discovery. I don't do that with my clients. And I only prepare them usually the day before or the morning of, in some instances, depending on the client. And that's largely just to manage their expectations and to calm them down and so that they know what to expect. But I don't have them go in there rehearsed with what to say, because that, I think, gets them into trouble. Because then they're trying to remember what they should say rather than what they know. And so what I tell my clients is, look, this is not a test you have to study for. It's just the other side asking you questions. They want to know what you have to say short or trial. It's called a discovery because they're trying to discover what you have to say. And I just talk about 3 golden rules. The number 1 rule is tell the truth, never get into trouble. Number 2, don't guess. If you don't remember something, better to say, I don't remember, or I don't recollect, I don't know, than to, try and say, well, I think it was this, or I think it was that. That's where witnesses tend to get into trouble. And then my 3rd rule really that I tell them is, look, keep your answers short. I can't make use of this transcript. Only the other side can. So this is not your day to tell your story. That will come later at mediation or trial. This is your day to just answer what the other side has to, the questions that they have to ask. So I say, 5 seconds or shorter. If you find yourself talking for longer than 5 seconds, you're probably talking too long. But, it's not a hard and fast rule. If the question calls for a longer answer, give one. But I tell my clients not to have verbal diarrhea at discovery. I don't want to hear that. But and it's surprising, the clients I am often most worried about actually end up doing really well at discovery, despite in prep, they can't keep focused and on track and they're all over the place. And then when they're in the moment, they do well. But that's my approach to discovery with clients. And, I walk them through some records that I think might be put before them, the pleading, for example, some medical records, so that they at least have some familiarity with what they're looking at when it's put before them. But I don't have them study it by any stretch, and I certainly don't give them copies to take home to study. Conduct in discovery. There is a great case in BC that I recommend every young lawyer have a read of. It's called Kovacs and Kayla. It involved two senior counsel from the Lower Mainland Bar. And, obviously there was a history there, and they didn't like each other, I'm sure. And all of us have had those experiences. And, often our conduct can be, we can be less than proud of our own conduct when we engage in these sorts of disputes with opposing counsel. And I can't say I haven't had disputes with opposing counsel, I have. But it's important to keep a cool head and recognize that when you're on the record, you're expected to behave professionally. This case really is a warning of what not to do from both sides. One counsel put his feet up on the table, was calling his opposing counsel by her first name. On one occasion, he left before the court reporter even showed up. There was all kinds of disrespectful behavior on both sides. And so, this case is a good warning. Like, first of all, you never want to be that lawyer who has those reasons out there. It's pretty embarrassing, I would think. Behave yourself when you're at discovery, be respectful. I just refer to my opposing counsel as counsel on the record. And it doesn't mean you have to be rude or abrasive. It just means you have to be professional. Don't interrupt. I always tell my clients in prep, I may not object at all during your discovery, because I only object if I have to. If there is a reason for me to interject. Sometimes there isn't. And the reason I don't is because I expect that same courtesy from my opposing counsel. Someone who is disruptive frequently is going to make for a very difficult discovery. And in any event, hopefully no one has that experience at discovery. Experts. This is the subject of a 3-hour lecture I give at UBC. So, this is going to be a really cursory review of experts. I do think cases are made or lost on experts, and it's really important to be able to identify the right experts, to be able to work with experts, to book experts. Sometimes that's a huge challenge, is to try and find the right expert and one that has availability. Down here we have huge challenges trying to get a psychiatrist, but I have a couple on speed dial that I work with frequently who are excellent, and they'll usually give me a cancellation if I need one. But oftentimes the wait list can be a year and a half long. So it's really important to turn your mind to what experts you need early on so that you can get that appointment. Choosing the right expert is important. The motor vehicle bar down here, the defense bar has been criticized by the courts quite readily for hiring orthopedic surgeons to comment on soft tissue cases. They're often black and white. They often don't say helpful things. And, they're not very sympathetic to subjective pain complaints. There's a great case called Cuttabo. I think it's Mr. Justice Saunders who made the comments, but just, the counsel have a duty to select the right expert that's going to be able to weigh in on the court. And while an orthopedic expert is qualified to give that evidence, he's probably not the right qualification to give that evidence. I mean, an orthopedic surgeon does, broken bones, osteoarthritis, that sort of thing. So pick the right expert. Physiatrist is better for soft tissue. Even liability experts, you want to make sure you have the right expert working for you. Admissibility, just be aware of the White Burgess case. That's the seminal case on admissibility. You want to make sure that your report is going to be admissible in the end. And if you're working with an expert who's really green, who hasn't worked in the court system before, you're probably going to have to spend a lot of time with them just making sure that their report is formatted and going to be admissible, that it meets all of the rules in terms of the admissibility requirements. And there's nothing wrong with doing that. There's actually a great case out of Ontario that I use when I'm arguing admissibility issues in court that says, look, it's perfectly appropriate for counsel to actually communicate with their expert on the draft report and say, look, I need to make this admissible. Here's what you should say, and how you should say it. And you're not suggesting that they substantively change their opinion, but you have a duty to make sure that that report is going to be helpful to the court. And so don't hesitate to do that. It doesn't mean you're asking them to substantively amend their position. It just means that you're you're working with them as a professional and as an officer of the court to ensure that their report is going to be helpful. So, and then the other suggestion I have as well is when you're working with an expert, keep in mind that they can really help you in managing the opposing expert and your risk on that. So when I'm going into a cross-examination at trial, I work with my own expert or sometimes an entirely different expert to prepare my cross-examination. And that's because, I want to know as much as possible what that expert knows. And generally speaking, there are 4 areas that we can cross-examine on safely without getting ourselves into trouble. Qualifications, is this the right expert properly qualified to give the opinion? And you can choose to cross on qualifications after the expert's been qualified. Unless you truly don't want them to testify at all, then you take on their qualifications early. Or you might strategically want to sort of take a dig before they give their direct so that the judge or the jury has an understanding that perhaps this expert is not what they're cracked up to be. But usually, I can save my cross on qualifications for the main cross just to attack the weight of the opinion. In one of my recent trials, it was a med mal, the defense psychiatrist who was commenting on standard of care in front of a jury. This was about 1.5 years ago, so before COVID, 2 years ago now in September. He appeared quite a bit older. He spoke with authority, but in fact, he was a mature student when he went to med school, and he'd only been practicing psychiatry for 14 years. And so I took that opportunity to have that early dig in my cross and qualifications. And I still conceded that he was qualified at the end, but I immediately undermined the strength of his opinion to the jury before he even said a word. And so, keep that in mind and look at your experts, look at your opposing experts, try to pick your holes where you can. Surprisingly, there are a lot of experts who engage in a lot of advocacy on both sides. I just recently ran a trial where I frankly I had a very aggressive cross of the addictions expert on the other side. And I had so much to work with. It was fantastic. I love a good cross, but his file materials actually had 3 draft reports. His handwritten notes were not properly relayed into his factual assumptions. And, that expert was trying to say that my client suffered from addiction in any event of his accident, which was a very serious traumatic head-on collision where he suffered a dashboard crash injury and he had PTSD. And, before the accident, he was gainfully employed, working full-time. And in fact, he worked the day of the accident, put in a full day, heavy drinker, but life is functional. And then after the accident, he's fallen apart, he's suicidal, he's getting admitted to hospitals, can't work, obviously, he's got flashbacks of the accident. And when he went to see the defense's addictions expert, you can see in the notes, in the real-time notes, that he's reported a number of bases for why his drinking escalated right after the accident, including his mother dying, his girlfriend breaking up with him, and he's suffering from nightmares and flashbacks from the accident. And interestingly, from the notes to the hard report, the first 2 made it into the hard report, girlfriend breaking up with him, mom dying, but the doctor does not include the note about the reported flashbacks or nightmares. And so I had a heyday with that in cross. It was great because I got to show that he's cherry picking. He is cherry picking the facts that support his opinion. So great way to show advocacy. And when I know an expert is being an advocate, I push their buttons. I look to get an aggressive response from them. And if they give me that, even better, because it allows me to polarize more and make sure I can say to the judge at the end of the day, that expert wouldn't even concede the most reasonable assumption put to him. He fought me back on everything. And so it's a great way to destroy an expert's credibility before the court. Another easy way, factual assumptions, anything in terms of, underlying the opinion. If there's an erroneous factual assumption, you can take a dig at that. Polarizing the case, again, this sort of leads into advocacy again, but you can suggest things to the expert that he has to disagree with. The non-organic findings, we see that in personal injury cases all the time. Orthopedic surgeons saying, there are non-organic findings, meaning that there's no objective explanation for the pain that they're complaining of. So you put it to the expert. You're not saying my client's lying, are you? because they're not going to say that, right? So you push them on those issues and you polarize, you get them to take extreme positions. I did a cross in that med-mal trial, which I'll talk a little bit more about. It was quite a sad case where I was acting for an elderly woman who was beat severely by a schizophrenic patient who had been released from St. Paul's Hospital and who was very clearly sick and psychotic at the time. And the defense psychiatrist was interesting. I mean, he was very much an advocate. He wouldn't even concede to things that the defendant herself conceded to. So I really took him on, and we were in front of a jury. So as much as I don't get too involved in theatrics, it's important to demonstrate when they're being an advocate. At one point, I actually picked up the rule book and I said, "Doctor, you realize that there's a rule against advocacy in this rule book?" And he said, "Oh, I haven't read that book." And I said, "I'm sure you haven't." And I put it down. Needless to say that we resolved the claim that evening on day 13 of a 19-day jury trial. The last bullet I have there is taking on the science. Generally speaking, you shouldn't do that. It can be pretty precarious because you're not going to know the medicine as well as that expert. Having said that, I have done it. And I've done it where I've been comfortable doing it because my expert has coached me on what I can put to that expert. So, if you're going to do it, be well prepared, know the medicine as much as you can, work with an expert who can properly educate you on it, but don't do it lightly, would be my advice. Each case is different and each case has to have its own risk assessment. And generally speaking, it doesn't hurt to have mediation or settlement discussions because at the very least, you can learn what the defense's theory of the case is. So take notes. You're not allowed to use that information or repeat what's being said, but you can certainly get some insight, and there's nothing wrong with that. But generally speaking, with my clients, what I tell them is look, if going to trial is not fun for anyone except for me. I like being in the courtroom. I like being a trial lawyer, but my clients tell me they don't enjoy being the plaintiff or being in the witness box, and that's understandable. Trial is a stressful process, not only on the plaintiff or on the party, but on everyone around them. All the collateral witnesses that have to come in, whether they're work witnesses or friends or family. It's really an arduous process and involves a lot of time, a lot of energy, and a lot of stress. And so I explain that to them. And plus, it also involves a lot of uncertainty. You're basically asking a third party to look at your case and make a decision, and that involves risk. So mediation is an opportunity to try and control the outcome and to try and find a compromise. I will admit that I'm not great at mediation. I think I'm more adversarial than that. I'm not someone who likes to compromise at all in my position. Having said that, I know that mediations are often in my client's best interest because going to trial is not for everyone. Going to trial also involves a lot of delay and then the risk of an appeal. And sometimes getting some money in your client's pocket now versus more money later is a decision that's a practical one for the client to make, as opposed to an assessment of the legal risk. But this is where I remind my client, of our discussion at the beginning of the file and my role as counsel. My first role is to build the evidence. That's done now. We're at mediation. Now it's my job to give you advice on risk. And, I always tell them as well, don't be offended by the first number. It's always ridiculously low and ours is usually high. But the important number is the last one that's left on the table. And that's the number I'm going to give you advice on. Is it in the window of risk? Is it a number that I'm not sure I can beat at trial? And I explain to them the cost consequences of not being able to beat an offer at trial. Basically my job is to give them as much information as possible and insight and legal advice for them to be able to be empowered to make that decision. But not all cases are suitable for settlement. Sometimes you got to go to trial, and you can't be afraid to go to trial. I have been in that position in my career before. Certainly when I first switch sides to the plaintiff side, I didn't feel like I was on my own feet yet. And I felt a little bit uncomfortable and my confidence wasn't quite there. But just do it, get out there and run the trial, because you won't ever find that confidence unless you do it. And once you've done it a couple of times, you've got that platform now and that foundation, and you can keep building on it. But don't be afraid of trial. If make it or break it, that's where you're going to realize if you want to be a litigator and if you like doing this. But the trial's not going to be a very pleasant experience for anyone, especially your client, if you're unprepared. So really important to properly prepare for a trial. I often work backwards. I start working on my closing argument well in advance. And, it's almost like a puzzle. I want to see all the puzzle pieces I need. What is the evidence I need? What are the legal arguments I have to make, so that I know how it all fits together at the end. But I prepare a lot, and I prepare my client as well, and all the witnesses. I never throw anyone on the stand cold. I want to identify the right witnesses to call. Who's going to say this piece? Who's going to fill this puzzle piece? Who's going to talk about the lost opportunities at work? Who is a good example of what my client could have been, but for the injuries? Who's earning that extra $20,000 a year in overtime? Finding those people and putting them on the stand is really important. My associate's little meme here, but I try not to rely on hearsay evidence if I can afford it, but invites a whole host of problems. But what I do like to do is rely on real evidence, demonstrative evidence, and like this presentation today, if I didn't have a slideshow, you'd just be looking at my face and listening to my words. You'd probably drone out if you haven't already. You may be doing that anyway. But images, visuals, sounds, real tangible evidence is what keeps the trier of fact engaged. Tell me a story. I actually think I've got this from Mike Slater's article or from David Bull, but tell me a story and maybe I'll remember it, but involve me and I will live it. I will, you will understand it. And so, I can talk a little bit about the case that I ran, the medical malpractice claim that ended up settling 3/4 of the way through the trial, or 2/3 of the way through the trial. In that case, for me, strategically, I wanted to tell a story. And this was a jury trial. We'd called the jury. Really difficult issues in this case. Just to recap the facts, my client, 60-year-old woman, a little over that, she was already previously disabled and was on a pension. She likes to walk every morning, and she was out for a walk in downtown Vancouver near BC Place. And out of nowhere, she is the third and final victim of a man who was truly very ill at the time, and in deep psychosis. And that's this man on the screen here, Mr. Osute. And she was very viciously attacked by him. He was kicking her head like a soccer ball. And she was in GF Strong for, I think, about 6 months. And she was left with no sense of smell, very little sense of taste, serious balance issues where she can't keep herself upright if she's on a bus, and some cognitive issues as well. But for the most part, she'd actually had a really good recovery. But it's interesting because we ended up agreeing on damages, what her quantum was worth prior to going to trial. And I was up against my former firm, Harper Gray, on this. So it was fun for me too, because I defended doctors for a long period of time, and then I got to go up against them in trial. But the nice thing is that I have a professional relationship with them, and we were able to agree on things we could agree on. So we agreed on the quantum of damages, and we just ran on liability alone. But jury trial, but the interesting thing is, one of the big legal issues in this case was whether or not the defendant psychiatrist, who we had named, owed my client, who was a stranger on the street and not her patient, a duty of care. And that was an issue for the trial judge to determine, not the jury. The jury was the trier of facts, the judge was the trier of law, and that's a pure legal issue. So it was interesting to do like a hybrid trial between jury and judge. And in that case as well, we had originally named Mr. Osute as a defendant, and I released him before trial on a BC Ferries. And I made him my protagonist in the trial. My client was the first to take the stand, but she was only up there very briefly. She has no memory of being attacked at all. She's got retrograde amnesia. She doesn't remember it, but I wanted them to meet her. But he became the central protagonist in the story. And I had him on the stand, and he spent 3 years in a forensic psychiatric hospital. He was an NCRMD, and then he was doing quite well. He was, got a master's in business. He was living with his mother. He's now on injectables. Very, very intelligent man, actually, and a real gentle giant. And so he took the stand, and he was a really likable young man. It was quite something for the jury to watch. And I actually played for him the audio of his arrest, which he had never heard before. And we sat there for half an hour listening to the audio of his arrest, and there were just tears coming down his face. Because in that audio, he's heard yelling that he is hunting down humans to kill them. And he's clearly unwell. And there's a lot of grandiosity, which speaks to the psychosis that he was suffering from. And he remembered clearly everything, which is interesting, including the admission to hospital the night before and what had happened. He was admitted to hospital the night before in the emergency room. He had actually gone to the police to ask for help because he knew he was experiencing hallucinations. Goes into hospital, emergency room commits him. And the next morning he has a psych assessment. The psychiatrist lets him out on the promise that he will take his medication. She sends him back to the downtown east side. Within less than 24 hours, the rampage happens. So a really sad case where the system really did fail him. And our case was focused on the doctor, what she missed. And she missed getting the records from his most recent admission to hospital in Edmonton just 6 months before. He self-reported that he'd been in hospital for 3 weeks. So that became the focus of the case, and he became my protagonist. And so that audio and that half an hour in the courtroom where all of us sat incredibly still and listened to this audio and watched this man, this 6 foot some odd man crying, was an amazing moment, really. Sorry. I was actually going to play for you. Hold on. Now I've got to try and go back. Hold on. How do I go back here? Previous. So I am going to play an audio clip of the 911 evidence. So we actually have a decision on this from Mr. Justice Voith. It's an intra-trial admissibility decision. So the other side was opposing my ability to lead the 911 audio, as well as other evidence that they said was prejudicial to them and that was inflammatory to the jury, including a photograph, which I haven't put on this PowerPoint out of respect for Mr. Alsute. But when he was arrested, he'd actually stripped down to his underwear. And the photograph was very important to me because it was an opportunity for the jury to truly assess this man's health at the time. The face, his facial expressions, the fact he's in his underwear, really, I think, demonstrated part of the symptoms of his psychosis. And because the interesting thing is that he remained a third party in this action because the defense was still pointing the finger at him, saying, "You're still guilty of assault. You still assaulted this woman," but he could have only assaulted if he had the mindset to do so. And so it was interesting too, tactically, for that to happen. It sort of played into my theory of the case. I made him my hero. They were still calling him the villain. So I got to say his own doctor, is blaming the patient for what happened here. This man is sick. He's unwell. But part of what I wanted to do was tell the story of what happened in order to explain the psychosis and what he was experiencing. And so we actually picked which witnesses, which bystanders we wanted to call. And there were 2 critical ones out of probably a dozen who witnessed what had happened, who had also called 911. And the opposing counsel was opposing our ability to play the 911 evidence. They said, surely this person can simply just tell us what they saw on the stand. That's good enough. The 911 audio is prejudicial. It's going to be inflammatory for the jury. And Mr. Justice Voith said, no, it is admissible. The 911 evidence is not to exaggerate the evidence of the plaintiff's attack, nor can we dilute it or sanitize it, which is what he said the defense was trying to do with their objection. The trier of fact is allowed to have a full and accurate experience of what was happening. And this is the best evidence we have of what was happening at the time. So I'm going to warn those of you who may be sensitive, maybe mute your screen if you want. But I'm going to play a very short clip of some of the 911 audio that was played in that trial. Oh, nobody can hear that? Oh, okay. Well, that's unfortunate. All right, that's too bad. You know what I will do? I will try to fix that at some point and see if I can't play it somehow. I wonder if I turned up my volume, if that would work, because you should be able to catch, the mic should be able to catch it. Oh, here comes my associate to help me out with the technical issues. Miss Leung, fix this for me. Okay.
Oh my God, I don't know if I can do this.
Go previous. Sorry guys, technical issue. I should have tested that out before. All right, let's see if we can hear it now. Megan, will you give me a thumbs up if you hear it?
Okay, ma'am, just stay still, okay?
Vancouver Police Emergencies.
Oh my God, you need 2 ambulances to right outside GM Place on Pacific Avenue where you go into the casino.
Okay, you got transferred to Vancouver Police. They also said that a person kicked and jumped on 2 people.
Oh, he's kicked and jumped on 2 people, and he's walking down the street. He's a black man. He's quite tall. He's got a gray hoodie on.
Okay, I need you to take a deep breath. Where did you say this was happening?
This was on Pacific Avenue, right across from GM Place, where you go into the casino, and the man is walking westbound. Who did this? He's tall, black, with a gray sweaty hood on, and I've got 2 people lying on the ground here. He's kicked them. He's jumped on their heads. And I said, we need an ambulance right away.
Okay, just stay on the line with me. Stay on the line here with me. And you said this is outside of GM Place on Pacific?
On Pacific, yes, where the parking lots are, the empty parking lots. So it's on the what side is this? The south side of the street.
One sec here, on Pacific, you said. On the south side of the street?
South side of GM Place. So you come along Pacific just after.
And is it in the parking lot?
No, it's right. We're right on the street here.
Okay, right on the street. Okay.
Yes, it's okay, sweetie. We're getting some help for you, okay, sweetie? We're getting some help. We just can't move them.
And you said he jumped on these 2 people?
He jumped on them and kicked their heads and jumped on them again. And then one man stopped and tried to stop him. Well, he was doing it again, and he went after him, but I think he's okay.
One sec here. Which way? You said he was going westbound where?
Westbound on Pacific.
Oh, sorry guys, it's probably a good place to stop it anyway. So I've listened to that hundreds of times now, and I still get goosebumps when I listen to it, especially at that one point where you have to send someone right away, you know, there's that panic in her voice, and you can't reproduce that on the stand. You know, this is the best real-time evidence of what was happening at the scene. And it was all relevant to his psychosis at the time. And it's interesting because in that audio, she talks about him, we cut it off before she heard it. She talks about him carrying his coat, but it's not further explained in the 911 audio, but I had her explain it on the stand. And he was carrying his coat over his shoulder and sauntering away from the scene. And that was incredibly relevant because it spoke to his psychosis and the grandiosity. And so really it dovetailed really nicely with our psychiatric evidence on his state of mind at the time. But you can see how real evidence, like picking the right real evidence and leading it, can make such a difference in a trial. And this was a fight worth having. You know, the other side wanted to keep this out for the life of them, and I was fighting to get it in because really persuasive in my view. Sorry, now it's wanting to play again. All right, so when you're in trial, you know, I think I've been accused of being quite aggressive on occasion. I wear my heart on my sleeve and I really get into it, but you know, obviously you've got to maintain your professionalism. I do as much as I can. And you have to adjust your style for the witness. You know, sometimes with some witnesses, you get far more with honey. You know, with some experts, I've been really complimentary of them and I sort of get more that way. But, you know, sometimes you want to have a really aggressive cross because you want to prove a point. But, you know, pick your style, adjust your style. And, you know, is credibility an issue? If that's the case, remember the rule in Brown and Dunn, you've got to put things right to that witness. If you're going to accuse them of being dishonest about something, you've got to put it to them directly. You can't just argue it later that they were lying if you haven't actually given them the opportunity to explain that they're not. you know, and we in Dhillon, which is the traumatic brain injury case that we ran over the last 2 years, I ran the liability trial in 2019 and the damages trial in 2020. And we did get a record award of 9 point, I think it was 1. And then by the time we resolved tax gross up, management fee, cost of disbursements, we were up almost at 11 million. So huge claim, but this young man, well, he's in his 40s, had devastating injuries. I mean, he couldn't cross the street by himself without assistance. And he is like a child. He's a lovely, lovely young man, but you know, no amount of money makes up for what he's lost, but he needs a lot of care. And that's largely the bulk of the award was for his care. But on the liability aspect of that case, you know, liability was very much an issue because he had technically rear-ended a tractor trailer on the Coquihalla Highway. The tractor trailer, however, we had evidence from the girlfriend that it was encroaching into his lane of travel at the time. And so this was, and the engineering evidence didn't help us at the scene because there was snow cover, the scene was disturbed by a number of first responding vehicles. It was very difficult to determine what had happened. And in fact, I didn't even have a primary engineering report to help me prove who was at fault for this collision. And of course, there's an inference of liability for a rear end collision. So I had an uphill battle on trying to prove liability. And it all came down to credibility, what the girlfriend passenger said versus what this truck driver said. And my cross-examination of the truck driver started with 5 impeachments from his discovery. So I had my outline ready, but after he finished testifying, I put that outline aside. I just had my 5 impeachments ready to go. And then I stopped for the day because we were at the end of the day. And that was a really effective way of impugning his credibility. And in fact, he wasn't found credible at the end of the day, and I got 100% liability against him, which is what allowed us to get that award in the damages aspect of the claim. Anderson and Molon was the Catholic Church file as well. You know, credibility was very much an issue. I took a good run at the Archbishop. The judge didn't necessarily go as far as I wanted him to on credibility, but so be it. But you know, with him, I actually started my cross off. Again, I used my canon law expert to give me what I needed to prep for that cross. But I actually put a Latin phrase to him from the medieval times called restitutio. I'm sorry, no, I'm not going to get it. But anyway, there's, I think it's restitutio mentalis or something, where many bishops in the Catholic Church have exercised this doctrine of what they call, you know, restraining our memories, i.e. telling a white lie or not quite telling the truth or telling a different version of it for the greater good. Oh, it's reservatio mentalis. That's what it is. Now I've got it. But I spent a lot of time with the Archbishop on that. And in fact, I had Rochelle, who was our articling student at the time, go to the Vancouver Public Library and get an old Catholic encyclopedia, which she had to get from the reserve section. It literally had dust on it, and it was this big. And I brought it with me to the courtroom, and I put it on the stand for him. But he acknowledged what it meant. He acknowledged he knows what it is. And it was a way for me to attack his credibility before I even commenced his cross. Because what you're telling me, Archbishop, is that, you know, the point of that doctrine and exercising that doctrine is that your audience doesn't know that you're lying. Isn't that right? So we don't know that you're exercising that doctrine here today. And, you know, I went on and on and on. So anyway, cross-examination, I think it's a lot of fun if you're well prepared for it. Trials, leave enough time for closing argument. I am the worst for this, and sometimes my trials go on and we need to find more time because there's not enough time. Anderson and Molon was a really complicated case, and I'd only scheduled the usual time for closing argument, which was clearly inadequate. But it's tough because you want to get your case on, you want to get your trial dates on and move forward. So anyway, try to schedule enough time. Post-trial settlements. Or judgments, you know, what to do after the trial's over. I mean, obviously, if you've had a trial, you wait for the judgment. That can take an awfully long time. If it's a settlement, you know, you want to make sure you're crossing all your T's and dotting all your I's. You've got to make sure, you know, releases, you want to review those for the terms, settlement agreements. You know, do you need a BC, what we call a BC ferry agreement here, which is like a, I can't remember what the old term for it is, but in any event, you know, if you've got multiple parties involved, you want to make sure everything's properly documented. Do you have any segregated interests you need to resolve? have a checklist of things you need to take care of at the close of a file. Do you have undertakings? Usually you would accept undertakings on the funds being transferred. Was there a previous lawyer involved who's put you on undertakings? Make sure that's being honored. Undertakings can't be taken lightly. I have an old mentor who said, don't give an undertaking unless you have to. He's like, the only time I do is if I'm, accepting money. So don't, willingly offer undertakings. Just say, I'll do my utmost to do X, Y, and Z, but it doesn't have to be an undertaking. Obviously dealing with costs and disbursements. I've just got a checklist of things that I think about at the end of a trial or settlement. If it is a trial, obviously, once you get judgment, you want to consider whether or not, if it's a win, great. If is the other side going to appeal, you want to think about all these things and prepare your client for the possibility of an appeal, like if the other side might do that, and what that means. And consider also getting a new retainer agreement for that as well. It's important to ensure that your relationship with your client continues to be documented. I'm actually, so this is about an hour presentation because I'm a bit early, which leaves us lots of time for questions, which is great. But my associate Rochelle had included some of these pictures because these are some of the people we've talked about, and I have the client's permissions to use their photos. Hold on, what just happened here? Hold on, I'm going to go back to that. 2 seconds here. Sorry, my mouse is a little bit too sensitive. So here we go. So let me introduce you to some of the people I've talked about here. This is John Berlin-Wee. This is the man who was traumatically brain injured in the Coquihalla. It's my daughter. She came to visit us on a lunch break. This was during the liability trial. This is Donna Crawford, who was the woman who was unfortunately very severely beaten by Mr. Osute and the medical malpractice claim. And you can see she's got a walking stick because she has to use that to keep her balance. And on the far right is Rosemary Anderson, which I can't move my little cursor here to move my window of people, but Ms. Anderson is the plaintiff in Anderson and Molon, which we took on the Diocese of Kamloops. And she had actually she was a survivor of clergy abuse, but she was a young adult at the time. And so her case is the first, to my knowledge, of an adult victim of clergy abuse bringing litigation and going through trial. And it was really quite an amazing experience. Miss Anderson is now 71 years old. And so she had literally waited over 40 years to do this, 45 years. And she's a very powerful, articulate, bright, intelligent woman. And since doing that trial, actually, we have participated in a couple of things. There was a CBC interview we did, which is shorter, but there's also, and there's a paper I think that's being circulated with a link to it. Thompson Rivers University in Kamloops actually invited us to do a podcast, and it's over an hour long. It's in 2 parts, just talking about our experience of going through trial. And she actually gives a lot of insight into what it was like for her as a client. First of all, to meet me, the retainer process, why she retained me, what it was like to go through the process of litigation, the ups and downs, what it was like to go to trial, some of her experience, some of the things that she thinks could be improved from her perspective as a litigant. So if you have time, I recommend you listen to it. It's the torts class at TRU, and there should be a direct link to it. But generally speaking, every single file I've picked up, I've learned something new. And that's what I love about this career choice, is that I'm constantly learning, I'm constantly growing. And, I think for me, respectfully, success isn't defined by, the house you own or the car you drive. It's really, the difference you can make in someone's life and feeling like you have been able to affect some difference. And that to me is the true sign of success, and also just feeling like I've grown as a human being. So there's my sentimental moment of the journey today. My associate thought it would be cute to include a photo at the end of my daughter and my puppy, because who doesn't like toddlers and puppies? but you know, this is truly what matters, is going to her at home at the end of the day. And you know, it's great to have a fulfilling career and a fulfilling home life. So my presentation is shorter because I didn't time it before, so sorry about that, Megan. But my thought is we can have lots of questions if people have them. And there is one from Brian Goldsworthy: is your personal injury course at UBC available remotely? And yes, I can make the PowerPoint available as well. And then there's there's a paper as well. And if you go to the CAS Law website, we actually have all of the lecture notes for the UBC class updated every year, and they're posted up there. So you're welcome to go in there and access them. The actual course itself is not live. We do, because of COVID this last year, we taught by Zoom. And the previous year, it was sort of mid-semester when I had to switch over, and there were a couple of PowerPoint audios. But because it is a UBC law course, I don't think we can open it up to the public. But certainly you can access our encyclopedia of lecture notes, which the first few classes, the first half of the course is all substantive law, and the second half of the course is all procedural and strategy and that sort of thing. And I think I saw another chat here, hold on. Oh, Rochelle is telling everyone we can upload this presentation as a PDF to the CAS Law website. Yes, we can do that. Happy to do that. Megan, why don't you ask me a couple questions to get the ball rolling?
Oh, geez.
I know, Socratic method, I'm putting you on the spot here.
No, I'm trying to think of a good question. Why don't you talk about, you know, the importance of like a good BF system when it comes to, you know, getting ready, taking on a file and prepping everything? Because I know that's sort of can be a pitfall if you don't have everything organized in terms of specific dates.
Yeah, no, absolutely. A good BF system is important. And of course, you know, you're required to have a couple, so you have a backup. You know, honestly, organization is key to this job for sure, from each individual file to the overall practice. You know, my BF system has changed with the times. You know, previously when I started practicing, I remember I literally would keep a pink copy of every correspondence and a yellow copy, and my assistant would drag it forward, and there were all kinds of systems, and I would do a monthly file review. And now, of course, everything's done electronically. But, you know, whenever I do a task, I usually do a little memo to file with a to-do list. And, you know, my paralegal is obviously a very big part of you know, a BF system and moving things forward. But, you know, on the plaintiff side, you've got to be proactive. You can't sort of sit back and wait for the litigation to happen. You've got to move it forward. And so obviously limb period's a huge issue if it's not sexual assault, and you want to make sure you can move it forward. But, you know, other issues as well, like you've got to diarize and push forward and set down discovery, set a trial date, because without that trial date, nothing's going to move forward. But, you know, obviously BF systems are critical to making sure that you're prepared and ready for a trial. Good question, Megan. Oh, here's some more. Hold on. Let's see here. Lenora Morris, how are you getting paid on these files, which I assume takes years to resolve? Yes, they do. I work on a contingency fee basis. You know, frankly, I'm not a partner in my firm. I don't really want that arrangement for myself. So I have the liberty of getting a regular paycheck while running these files, because my employer took on the risk early on to start the file or to start the firm. So, you know, personal injury it's an expensive area to work in. Like it takes a lot of capital to run these files properly and to spend money on them. You know, of course, our clients are often, you know, they don't have the money to spend on experts, et cetera. Very few of my clients do. I have a couple of med mal clients that, you know, they've given me retainers for the disbursements because they're risky claims, but they want answers. But very few of my clients have that kind of capital. And so we don't get paid unless they get paid. So, you know, the contingency fee premise is an interesting one because I think it obviously incentivizes us to ensure that we're taking on meritorious claims, to ensure that we're getting the best result possible for our client, because the more our client gets paid, the more we get paid. So we're aligned in interest in that way. And I do think overall they're really helpful because they, they provide access to justice to a group of people who otherwise couldn't afford lawyers, and good lawyers at that. A contingency fee can be quite lucrative if things go well. And so, the plaintiff's bar can be accused of being ambulance chasers and that we're taking advantage or making money. But on the flip side, it gives accessibility to justice to a subset of people that otherwise wouldn't have that access. And it gives them access to good counsel, because it would be really hard to attract good counsel to this area of practice if it wasn't financially worthwhile to do it. So yes, I don't get paid unless my clients get paid. Well, I have a different arrangement with my firm, but the average plaintiff's firm who runs their own files, that's the way it works. But if you do this long enough, you have that capital built up and it shouldn't be a problem. Next question. Since so many matters don't go at all to trial, do you have any recommendations about how to gain cross-examination experience in particular? I would really like to improve my skills in that area. Yeah, it's interesting because I've had the benefit of really getting into trial quite often. And absent trial, how do you gain cross-examination experience? I assume maybe there could be a CLE on cross in particular, which could be helpful. Cross is an interesting one though too, because you learn a lot by osmosis, by watching other people and by being in trial and sort of absorbing it. So if you have a chance to even go and watch trials and watch other cross examinations, go watch it. I learned a hell of a lot from my mentors. I was really fortunate to work for some really good lawyers. Chief Justice Hinkson of the Supreme Court of British Columbia was one of my former mentors, and I've seen him cross. I only worked with him a couple of years before he went to the bench, but he had a very different approach and manner. He was very soft in his cross. He's very soft-spoken, but laser focused. And cross-examination, I think, is an art as well. Like, it's not something you can't copy what someone else's style is. I think you just have to go in and feel it. And if you know your case, you can go in and do a cross, and just know your parameters, know your boundaries. Like, know that you shouldn't ask a question you don't know the answer to. Be really cautious about taking on science with an expert, because you're probably going to come out losing that battle. And if you are going to do it, you better know that science really well. So, sometimes you can even have your own expert sitting behind you in the courtroom, and on the break sort of consult with them and say, like, what do you think I should do on this? But preparation is key. And I think, if you can find someone who does go to trial a lot, see if you can tag along with them. Hopefully that can get you in to the courtroom. Absent that, I don't know what else you could do to try and get more experience, mock courts, that sort of thing. Okay, is there another question here? Darcy Kachuk. It seems to me that one civil litigation issue that can be deficient is pleadings. My observation is that many lawyers do not seem to be aware of the importance of good pleadings, nor some of the fundamental rules of pleadings, i.e. plead facts, not law, don't plead statutes, etc. Could you provide some direction about pleadings and some sources for good pleading language? Again, I'm the first to profess that my pleadings aren't always perfect either. But there's a lot of decisions actually on pleadings as well that sort of tell you what's good and bad. And actually in the paper, I've included a reference to an employment case that talks about the, what pleading should be and what the plaintiff's burden is in terms of drafting a pleading. I feel like I could probably find a pleading precedent. And actually, if you go into our UBC page on the CAMSOL website, there might be some pleading precedents there in the pleadings lecture. If not, you can email me. I'm happy to share whatever pleadings I have. I tend to go to precedents and then sort of recreate from there. But I can tell you, Anderson and Molon was the first plaintiff side sexual assault case I ran, and I'd literally picked that file up from Rosemary 2 months after joining the plaintiff's bar. And so I had no precedent to work from, and I borrowed one from another lawyer in town that I knew did this area, but honestly, it was verbose. It was full of evidence and fact, and it was, I'm embarrassed by it now, which is one of the reasons I amended it at trial. And my pleadings are still a work in progress, but yes, you can't plead evidence. You've got to be concise and careful in your pleadings. So I'm sorry, I don't know if that answers your question, but I assume there are various resources that you go to for pleading precedents, but I think the best one is call up a counsel that practices in the area and say, look, do you have a precedent you can share with me? And they'll send it. Megan and I have done that with each other. So I think that's your best source. Okay, and there's some questions in the chat as well. So let me go in here. Corinne McKay, is there specific training that you have done with respect to interviewing clients of sexual assault or residential school survivors? Just curious to know what resources are out there. There are some good resources that I'm continuing to read and try to educate myself. I can tell you very personally that one of the reasons I think I can interview clients from that well is I'm actually a survivor myself, so I get it. And I often do share that information with my clients so that they understand that I understand what they're experiencing. And by sharing that experience, hopefully that can give them some strength and some optimism going forward. But working with survivors of sexual assault, I mean, it's very difficult too, because it's difficult when you're also trying to manage a larger practice, because especially with everything that's happened recently with the Kamloops residential school discovery, a lot of my clients have been triggered. I don't have a lot of residential school survivors because so many of those settlements obviously were legislated, but I have a lot of Catholic abuse survivors, and it's tough because it's hard for me to drop everything else and attend to their needs, but it's also an opportunity for me to remind them that while I'm here and I'm sympathetic and I understand, I'm also not their counselor. I'm not qualified to be their psychologist. I'm their lawyer. And so I just connect them with the resources that I hope will help them. And I certainly do that from the beginning of every file I have with someone who's a survivor is tell them, look, you need to have a professional that you're working with that can help you through the ups and downs of litigation, because that can't be my role. I'm not qualified to treat them for that or to counsel them. But there are lots of great resources. And I recently read one. I'm going to see if I can find it. And then I'll if you want to email me afterwards, I'm happy to share it. But there was one on trauma and managing clients who have trauma and trying to be sensitive to those needs. All right, another one from Darcy. Getting experience with cross-examination. A tip to get more cross-examination experience is to participate in administrative tribunals that allow questioning of witnesses and to also practice during examinations for discovery. True. With examinations for discovery, I mean, very rarely do I go hard at a witness at discovery. It's not really, I don't see it as appropriate to really test credibility as the same way as you would at trial, but certainly questioning and leading questions and that sort of thing. I think it's an opportunity to practice that skill set to some degree. Brian Goldsworthy, what are your thoughts on joining counsel at another firm on a file? I have been invited to do that previously. I think it depends. My practice is incredibly busy right now. I'm busier than I'd like to be, and I think I have about 7 trials booked for the fall, so I'm a little worried about my calendar coming up. But certainly in the longer term, I think it's wonderful to be able to collaborate with other firms. And our firm does work with another firm in town that does class action work or some of our product liability work, and it's a really fun way to practice, to sort of get to know other colleagues at the bar. So always a great idea. Practically, it can be a bit difficult if your practice is a bit busy. Another question, earlier in your career, how did you bring in or find clients? Assuming now you likely receive referrals being well established. It's interesting because I have reestablished myself a few times in my career. I started out on the defense side. I was called to the bar at Harper Gray, worked there for 8 years, did medical malpractice defense, insurance defense, had an opportunity to get involved in the aviation work, left that firm when I was 8 years of call, actually ended up getting some aviation insurance work out of London myself as a junior associate at the next firm I went to, which is where I met Megan, did more insurance defense work there, was trying to build sort of a Lloyd's practice, then moved firms again, really enjoyed the people at that firm. At that point, I was, 10 years at the bar and sort of thinking, is this really what I want to do for the rest of my career? Do I want to do insurance defense? And it's tough because I spoke to a friend of mine. She's like, well, the problem is your profile is now very well established in that it's not like you can just go to a firm and do commercial litigation and start again. And I thought, well, maybe not that, but I could do something different. And you know, it's funny when you start thinking about different opportunities, how the door opens. And I actually parachuted into a defense trial with a junior who'd never been to trial before. And it was just a simple ICBC case, but I sat second chair and mentored him through that trial. And Castle was on the other side. And they beat me, but I gave them a hard time. And they ended up calling me up and asking me if I wanted to join them. And I thought, you know what, why not? You know, I'd worked for over a decade building my aviation defense practice. And it was a lot to walk away from because I was really close to a lot of my clients and I felt like I'd worked so hard to build it. But then when I switched over to the plaintiff side, you know, it just felt like a fresh start. And, you know, I didn't want to travel anymore either. I wanted to have a family. And so traveling for the insurance defense work it was really getting old for me. But when I landed on the plaintiff side, I mean, the sexual assault work literally landed in my lap. I mean, Rosemary came to me 2 months after I'd landed at the firm, wanting me to review a retainer agreement that she had for someone back east. And I wasn't even sure I could take on her case at the time because I would come over to do motor vehicle injury work. But I sort of took her on, ran the file off the corner of my desk for a while, frankly. And then because I ran the trial now, it's just ballooned. So I don't know. I mean, I've never advertised. I've never had to look for clients. But I think just doing the work, doing it well, caring, having that reputation, I think goes a long way. And, you know, frankly, running that trial with Rosemary has now resulted in a flood of that work coming to me, you know, probably more than I can handle, frankly. Next question. Is there specific training that you have done with respect? Oh, no, I already got that one. All right.
Sandy, question.
Yeah.
What about, I mean, you definitely touched on some client management, but maybe you could just go into a bit more in terms of tips, especially for, you know, lawyers just starting out. I mean, what they can do to ensure that they're managing their client throughout the process, because certainly in various areas of law, it can be difficult. And I think that's probably one of the hardest aspects of our job sometimes is managing our clients.
Yeah, and one of those early slides I had about, you know, is litigation worth it, is, you know, some of our clients can be really lovely and some of them can be not so lovely. And, you know, honestly, sometimes it's the ones that are not so lovely that need the most help. You know, sometimes there are mental health conditions that underlie their behavior. And so my number one rule is to try and not take things personally and not to personalize that behavior. You know, often you're just the easy target of a difficult client's frustrations. And so I just try to reframe things for clients who are difficult like that. I just sort of tell them, look, you know, I'm not the enemy here. I'm here to be your advocate. And sometimes that's a soft discussion and sometimes that's a very pointed discussion. Because there's some clients that will take advantage of you and walk all over you if they can, if they're given an inch. So, you know, I think if you can be emotionally intelligent and, you know, try to appreciate when you've got a difficult client and sort of how to manage them, you know, ask a mentor for help if you need it, for client management strategies and that sort of thing. So yeah. Okay, there's another question here. Hold on. Dan, is this Dan Shire? Yes, it is. Sandy, did you talk about your own self-care? I had to pop out and let Gabriel Hirsch in. Tell Dr. Hirsch I said hello. Yeah, self-care is important, especially when you're dealing with really, really difficult clients and trauma and challenge. You know, managing your own self-care, really critical. I mean, I've actually been quite open about my own mental health challenges over the years, and I've been just invited to speak for a mental health forum for the CLEBC and Law Society on September 14th. I believe it'll be a free seminar. You know, ask for help. The Lawyers Assistance Program is great. You know, if you're struggling with something, you know, ask a mentor, but you have to take care of yourself because this is a really difficult area to practice in. So I'm just going to take a note from my associate here. I apologize to everyone. I'm actually in the middle of a mediation right now. I've managed to double book myself. That's a bad BF system. So and Dan, it's nice to see you or hear from you. Any other questions?
It doesn't sound like there's any other questions. Sandy, I want to thank you so much for taking time out of your very busy schedule to educate us. It's been a wonderful seminar. I've got my entire firm watching right now. And obviously great to see you, because with COVID, it's been very difficult to see one another. And I presume if anyone's got any questions, they can send you an email.
You bet. Yeah, easy to find me. Just Google my name, Kaz Law. You'll find my contact details there.
Great. Well, thank you again, and look forward to when you can come up to the Yukon.
All right, I'll be there as soon as I can. Although you guys have more COVID numbers than we do right now.
That's true.
Yeah. Yeah. All right. Thank you, everyone. Thank you very much for having me. Megan, thank you for the invitation. And Lynn, thank you for welcoming me to speak with the Law Society. I really appreciate it.
Great. Thanks, Sandy. Good luck in your mediation.
Okay. Thanks, everyone. Take care.